this, the connection between our profession, our nation, and politics is embedded in Kenya's laws. That provision we must decipher its purpose, and we must decipher its meaning. I refer to Section 4E of the Law Society of Kenya Act, Chapter 18, Laws of Kenya. And it's an old law, it's a 1948 law. And it sets out the objectives of the Law Society, which it incorporates in another section. And this is what the famous Section 4E says. The objects for which the society is established are A, B, C, D, and E, to protect and assist the public in Kenya in all matters touching, ancillary, or incidental to the law. To protect and assist the public. In this context, in this provision, the word protect is an intriguing concept. Protect from whom? Protect from what? And when we say protect from whom, not against fraudulent tricksters, or murderers, or thieves. We are protected against such persons by the penal code and the laws of compensation. It is, I submit, protection against those who violate the law in a more fundamental way, by denying law itself while pretending to be its custodians, by being amongst those who take office by law and then deny the supremacy of that very law. It is against those who violate the rule of law that the principal protection is envisaged. And that protection by statute must be offered by the Law Society of Kenya. That's our objective. And so, this empowerment of the Law Society by statute is important. Its implementation by its members, we, us, is critical. And this implementation is our and our society's first and foremost duty. Because we have to ask the question, why the word protect? Because when those who control the state and its machinery use it against the people, or sections of the people, or individuals within it, or only for themselves, and thereby harm the remainder of the people, this section is saying there is only one organized body which can protect the victims, and that body is the Law Society of Kenya. I can find no such parallel provision or objective set out in any other statute governing professions. Medical, accountants, medicine, accountancy, engineering, architecture. I don't find that provision in the statutes which incorporate these bodies. The practical application of that statement of the law is that the members of the Law Society, the advocates, are the only persons who have been identified by statutes as persons to protect their fellow Kenyans. What Section 4E is saying is that in these circumstances, which is either the breakdown or the near breakdown of the rule of law, or the threatening of the breakdown of rule of law. We are all familiar under the Constitution, Article 19, 20, 21, 22, 23, etc., that it is not only a violation of the Constitution that is protected, but a threat to the violation of a provision of the Bill of Rights is also actionable. And that is why we go to the courts constantly for an injunction to bar the threat from becoming reality. So, even where there is a threat from the executive, it is the duty of the Law Society of Kenya and its members to resist and to move against that threat and prevent it from becoming a reality. Why does this section expect protection from us advocates and not, say, others? Why not the press, for example? Is it because we are generally trained in the knowledge of the law? Maybe, but others also, to a lesser degree, but others also know law and know the law of the country. Is it because we are specially trained not in law but in justice, trained in constitutionalism, trained in the defense of the component parts of the rule of law? Yes, I believe that is the reason. But I posit another reason, another unspoken quality that we carry. I hope we do carry that quality. I believe that the statute imposes this duty on us because it believes that we, the members, carry within ourselves those beliefs about the rule of law, justice, and constitutionalism. And we bring it into our profession and we keep it with us as we pursue our profession. That the statute believes that these are professional beliefs, but that they are also the personal beliefs of the overwhelming majority of our members. Not only are we trained in these areas, but we believe in those values. And this statute is taking it for granted that that is why we became lawyers, or why we stay as lawyers, or why we take on arduous tasks of caring for others, becoming magistrates, becoming judges, because these are hard tasks. These are tasks which take away from our personal lives, because we are carrying something within us which says this is what we believe. Not only, therefore, not only is this true I believe, of the overwhelming number of our members, but the converse is also true. If we did not believe these beliefs about the rule of law, about justice, about the democratic content of the rule of law, we would not be able to protect anybody. Section 4E would become odious. It would be incapable of being performed by those who do not believe it. So that this small provision in this is because the statute believes that we carry those beliefs. And bluntly again, in this, when we say the section, we mean Parliament, and by Parliament, we believe the people. So what is happening in this section is that our fellow citizens are looking to this society and to its members, to protect them. And so they expect us to practice our profession as advocates, together with those beliefs, and moved by those beliefs. And that is how we will protect.